Well, good morning, everybody. Thanks very much for joining our webinar today, in which we'll be looking at trading with Europe in a post-Brexit world. Brexit is looming larger and increasingly at the front of mind for many of our clients. So we thought it was timely to put on this webinar today. I'm delighted to be joined by my partner, Paul Samrah, who's Moore Kingston Smith's Brexit Impact Specialist. There's a title. Paul will take us through the things we should have on our Brexit impact plans. He'll then be joined by a Q&A by some more experts, one of our corporate tax specialist partners, Mark Filden, Geraint Lewis, who is a VAT Specialist Director, and Richard Cummings, who is Managing Director of our HR consultancy. My name is Mandy Merrin and I'm your chair for today. Questions can be posted in the Q&A function. Please post them in that and not in the chat, because it makes it a lot easier to track down the questions. Many thanks to those who completed our poll and who have submitted questions in advance. We will follow up the session with a copy of the slides, some frequently asked questions around the topics we've covered, and a link to the recording of the webinar. If you've got specific detailed questions, and there are quite a lot in this area, then can I suggest you get directly in touch with your Moore Kingston Smith contact, and we can pick it up from there. We will also include a feedback poll, and can I put my normal plea out there that we are incredibly grateful to those of you who take just a couple of minutes to complete the poll and tell us what else you'd like to see and how we did and how we can do better. It's incredibly valuable to us and really helps us continue to improve the quality of the webinars we put on for you. So with that, it's now time, I think, to start talking about what is actually an enormous topic. So I will hand over to Paul. Paul, take it away.
Thank you, Mandy, and good morning, everyone, and thank you for joining us for what is the perfect antidote to COVID-19, Brexit. As Charles Dickens' immortal words from A Tale of Two Cities perfectly sums up the Brexit landscape and the diametrically opposed viewpoints. It was the best of times, it was the worst of times, it was the age of wisdom, it was the age of foolishness, it was the epoch of belief, the epoch of incredulity, it was the season of light, it was the season of darkness, it was the spring of hope, but it was the winter of despair. Well, setting aside our personal views, this is what we're going to run through over the next 35 minutes or so. The screen works. It's a bit slow, I think. Right. Seems to be a bit slow on the screen. Moving on. But I will keep pressing the button. Anyway, the menu du jour, what we're going to tackle today is where we are now, looking at the people aspects, trading risks and opportunities, crossing over into goods and services, VAT and contracts GDPR, and some action points there for you all. And then we'll go into the panel. So it is a fairly full-on session this morning. Okay, so I think that's great. So as we know, March 2017, we had Tim Barrow handing over the letter, and that was 1,300 days ago, and we're 77 days away from the transition period ending on the 31st of December. And of course, the UK has left the EU. It left the EU on the 31st of January. Negotiations are continuing, as we know, and Ursula von der Leyen, the President of the European Commission, as well as the President of the European Council, Charles Michel, are attending the EU Leaders Summit today. We may get some more information from that, but certainly a deal hasn't yet been concluded. To be ratified in time, any deal needs to be presented to the EU Parliament by the 26th of November. Both parties appear to want a deal, but they are preparing for a future without one. And the key areas of contention, fishing rights, state aid and governance, main stumbling blocks. So how will Brexit affect business? Being a member of the EU has given us the four freedoms. We have free movement of goods, services, money and people. And you'll see by that chart there, there's so many aspects of running a business that are going to be affected by Brexit. Who will feel the impact? Those businesses that are rooted in the UK will certainly have labour issues and are facing labour availability. And indeed, from our poll, 41% said this was going to be an issue. The more mobile businesses, such as tech businesses, can flip from country to country. The less financial and emotional investment they have in the UK makes that relatively easier for them to do so. But the interconnected, the multi-Euro national companies heavily invested in the UK, but with an integrated supply chain, they face the biggest impact. So on to the practical questions. Thanks, Kirsten, go on one more slide. So 4 key points here. Who can I employ? Can my goods cross borders? What standards must my products meet? And what extra charges will I face? Now, that slide was meant to be green and red. It seems to have been distorted on my one to different colours. But the top 2, meant to be in green, they effectively, the changes have already been affirmed. We know by and large that we are firmed up on what we have to do. Where we are waiting on a deal or no deal, as the red, the points 3 and 4. A deal will provide clarification because there is considerable uncertainty about contracts and regulations and tariffs and duties. So on to people first off, and what's happening with people. Now, by the 31st December, if individuals have been living in the UK for 5 years, they're free to remain and can apply for permanent residence or British citizenship. If you have staff that have been living in the UK for less than 5 years, but they've been here, but they just haven't clocked up the 5 years, they can stay until the 5 years are up and then apply for settled status. And family members who are here in the UK before 31st December, again, can also apply after 5 years. And this is mutually being adapted by EU27 in reverse. So the EU settlement scheme applies to European Economic Area citizens and family members who entered the UK by 31st December 2020. And they must apply for either settled status or pre-settled status by 30th of June next year. So that is a real action point for your teams to make sure that if you have anyone in those categories, that they should apply for pre-settled or settled status accordingly. The actual process is quite straightforward. There is an app available. It's free. And for settled status, you only need evidence for 6 months out of every 12 for 5 years in a row. For pre-settled status, you only need to show that you've lived in the UK for 1 day out of the last 6 months. But of course, that is pre-settled status, not complete settled status. Now, for employers who are looking to recruit staff, the free movement of people ends, as we know, at the end of the year. And if you are looking to recruit from outside the UK labour market, then there will be some hoops for you as an employer to go through. You would have to be licensed as a Home Office sponsor, licensed sponsor, the cost of which is a one-off fee plus an annual fee to renew, depending on the size of the business, probably looking at about £1,500 on an annual basis. Then on top of that, you've got the immigration health surcharges, maybe some priority service fees to speed things up, and translation and third-party fees as well. The whole lot probably takes about 8 to 10 weeks to arrange and to get your license sponsorship in place. And then when you're looking at candidates, The candidates must speak English to the required standard, and the various tiers have been expanded. There's a skill level for tier 2 has been reduced to broadly A-level standard education. On that basis, you can engage and recruit. And looking at the minimum salary threshold for that level, 20,480 per annum if the job is on the shortage occupation list. Otherwise, the minimum salary threshold is 25,600. There is a different tier level, tier 2 ICT, which is for temporary people, maximum stay 5 years or 9 years if your salary is 120,000 or more, but it will not lead to permanent UK residency. So action points for employers, for your existing migrant workforce that you have, identify them and make sure they are in a position to apply for pre-settled or settled status. Look and review where your workforce is based and when any visas may expire. And be aware that visa application centres closed during COVID, so there is a backlog and delays. Be mindful also, I think it should be pointed out, if you've got short-term business visitors who may end up changing status, be careful on that. Diarise the expiry dates for pre-settled status and make sure, as I say, that everything is in place before 30th of June next year. Ensure that your contracts of employment refer to conditionality on having the right to work. So if they don't have, the individuals have the right to work, then you can terminate their employment. And diarise regular right to work checks. Consider being a licensed sponsor if you're looking at your talent pipeline to see what skills and labour needs you have. Yeah, we will be sharing the slides afterwards, just a message just come in. No problem there at all. Okay, so on to goods. And there are going to be significant issues around the movement of goods. Question marks over whether tariffs and customs duties are going to be payable. That is dependent on a deal or no deal. We have the default situation, which I'll come on to in a moment. But regardless of whether a deal or no deal is concluded, there will be significant customs paperwork, customs declarations. And that seems to have been probably missed by the mainstream press, in that actually everyone is talking about if there's a deal, then everything will be as before. Well, it isn't, because compliance paperwork is going to be the key. It may well be electronic, but it is still compliance, laborious admin to complete. And that will lead to delays at borders potentially, which may well have a knock-on effect on your supply chain. There has been talk on the number of UK lorries allowed to enter the EU. Heaven forfend that might happen. What could possibly go wrong? Well, we've got additional admin, we've got additional costs, we've got additional delays, but certainly we could have a situation where the trucks can't get to the port to collect or drop goods off, and the government fails to bring in the new customs systems on time, and of course failing to prepare could lead to chaos. The Garden of England could turn into a giant lorry park. If we can go on to the next slide. And the headline a few weeks ago, lorries will need a permit to enter Kent. And that is definitely happening. They will be issued to drivers who have received a green or amber rating from the new government smart freight system, which is designed to ensure that goods are ready to cross the border before their journey begins. And there is a fine of £300 personally on the driver if they don't have a Kent access permit, a KAP. Logistics UK, who were formerly the Freight Transport Association, has previously warned that 2 minutes extra processing time at Dover would result in a 17-mile queue. It doesn't really bear thinking about. Quite ironic, actually, that the government's new zippy new Brexit information campaign called Let's Get Going may well be slightly miscued, with hard borders, of course, delaying UK goods actually going anywhere. So the UK border, let's just go back. So the UK border operating model has been published, and it talks about the various checks that importers and exporters and hauliers will need to comply with to trade with the EU. And that runs to 206 pages. It will cover multiple loads under one umbrella number, and all the various issues surrounding the customs paperwork. Very important that your master databases are properly populated if you are exporting goods, and that all fields such as country of origin, tariff code, weight of the product is properly completed, and labelling needs to be attended to as well. It may well be that you might have to put your labelling in various different languages. The smart freight systems are the way that the government will monitor all the vehicle movements and checking the paperwork, and new border inspection posts are being built as we speak. Now, this slide featured in one of the raconteur articles that features in the Times from time to time. This was focused on the global supply chain in light of COVID. But I think this is just as appropriate for Brexit as well. And looking at those figures on the left-hand side, total of some 56% are showing that businesses are considering, to some extent, moving some of their suppliers more locally. And that, I think, we will see with Brexit a shifting. There will be opportunities for businesses to repurpose their supply chain, perhaps more locally. Moving on, obviously the effects of moving into a post-Brexit trading position, rising prices, whether or not you pass those costs on to consumers, whether the costs are tariffs or not, it may well be that, of course, the costs of all the admin for exports and imports into the EU 27 will affect the pricing of your products. And maybe as a result, there might be a reduction, perhaps, in the EU 27 demand for UK exports. But there are always opportunities. The opportunities to offset the additional costs by increasing domestic sales, as I've said, talked about the supply chain, more local. But on a positive note, if you are Brexit resilient, and certainly from the poll there were some businesses that said they were Brexit ready completely, well, if you are Brexit resilient, you should shout about it. You should advertise that fact and wave the flag, because businesses will flock to you, I'm sure, if you're absolutely passing all the tests and you're on top of everything. And of course, exiting unprofitable lines or make them more profitable by changing your supply chain. So it's another graphic showing the COVID effect. The point was there was 63% experienced stock shortages during the early stages of COVID. 33% were balancing stockpiling with cash flow, and that was their biggest challenge. Well, these graphics have just as much implication on Brexit as well, and with some 30% in our poll indicating that cash flow hadn't been fully considered, it is quite significant to ensure that you do pick up on the cash flow implications of trading in the post-Brexit world. The government auto-enrolled all businesses that exported and imported with an EORI number in late last year. Originally, you had to apply for it, but certainly you need to make sure you do have it to hand. If you haven't got it, or you can't lay your hands on it, there is the link there, and all the slides will be distributed later, as Mandy said. So all the links that are in this presentation will be available to you. So you will certainly need your EORI number. Then if a free trade agreement is not in place, then we are looking at tariffs. And the trade will operate under UK global tariffs, and the list of goods is all detailed there. The baseline, it's a baseline for trade with the EU 27. So if a free trade agreement is not concluded, we will be looking at 10% tariffs on cars being imported into the UK, 0 tariffs on Christmas trees, although we'll have missed Christmas by the time this is all concluded. But pharmaceuticals and medical devices, including ventilators, are 0 tariff free. And it's estimated, the UK government estimate, that 60% of the trade that will come into the UK will be tariff free. So if you're wondering as to how to check your global tariff, the UK global tariff for your products, do search using the commodity code, the product description, and a combination of those. That's the link there, and you can actually check. Goes into minute detail. In fact, we've got a couple of slides coming up here. That's what you land on when you click on that page, and I've gone for cheese, and that's the specifics: processed cheese, not grated or powdered, etc., etc. So quite specific, quite detailed, but you can actually apply for a binding tariff information decision, a BTI, which is a written tariff classification. It's not a legal requirement, you don't have to do it, but it is valid for 3 years, and it will help you make sure that the customs duties have been calculated correctly in advance. And that's the link there on that slide. So you will need your government gateway user ID and password, your EORI number, as I've said, and you might need to provide a sample as well as detailed information about the goods. The other number that you may want to seek to apply is the AEO, the Authorised Economic Operator status. And this is a sort of a kite mark, a safe, compliant trader kite mark. It confirms that your customs controls and procedures are efficient and compliant. It's not mandatory. It's likely to fast track you through some customs procedures, but I have to say that it is not quick or straightforward to apply. It's a rigorous self-assessment of internal processes and controls, and the AEO audit is done by HMRC, and they have a legal allowance for 6 months processing time. So don't underestimate the time and resources required to apply. It certainly isn't a one-day job to go through the form, and failed and incomplete applications go to the back of the queue. So ensure that you have completed all the questions correctly before you submit. And as I say, there is a 6-month legal time frame before you actually will get your AEO status. And so where are we? At present, there are some 141,000 traders that trade with the EU and or the rest of the world. And businesses exporting to outside the EU will be familiar with customs declaration procedures. But if you look at that wonderful Venn diagram, there are estimated to be 180,000 EU-only traders, and businesses that export to the EU only will face a whole new ballgame. And whilst they may already export outside the EU, it might be on the low side in terms of numbers. EU exports might be significantly larger. So bear in mind the volumes of your trade. In terms of contracts, international commercial terms or INCOTERMS, strongly recommended, predefined. These are predefined commercial terms relating to international commercial law. And the seller should use one of the INCOTERMs from the 11 that are suggested in all international contracts. So whether it's free on board, cost and freight, carriage and insurance paid, or the like, it should be absolutely crystal clear as to who is responsible for what. If there is a Brexit trigger event that causes an adverse impact, it's going to have contractual consequences. So be very clear about your obligations on delivery, delay, customs and border costs, transportation, supply chain security, and maybe have a specific Brexit clause. If you're importing, make sure you've got, go on to the next slide, the basic document requirements, country of origin and origins, the certificate of origin, if applicable, know your commodity code, have special licenses if required, make sure you've got your INCOTERMs. And it's important that you note that someone has to be the importer of record and deal with the paperwork. And that importer of record, if we click to the next slide, that importer of record is the person or entity responsible for ensuring that goods are correctly valued, the taxes and duties are paid, and all documentation is filed. So that importer of record could be the owner of the goods at the time of import, or it could be a customs agent or customs broker. But it is absolutely vital that you clarify who is going to be the importer of record. It won't necessarily be the end consumer or purchaser. The responsibilities with the importer are heavy. So looking at the customs controls at the UK border, we have full UK border controls from 1st of January, but there is a 6-month staged introduction to full customs controls for imports from the EU 27. So you can opt for being outside of that until 1st of July. But drugs, guns, excise, alcohol, etc. are all excluded from that staged introduction. But you may not want to opt out of the full customs controls because, of course, you may need 2 systems, one for EU 27 and one for non-EU. So be aware of that. But remember that the other side of the channel are not doing staged controls. So exports from the UK could still well be delayed. And customs declarations, to give you a feel for the numbers, are likely to increase 5 times to 300 million transactions, declarations per annum from 60 million. So ask yourself, how many customs declarations will I need? Should we develop the ability to make our own declarations? And also remember that customs declarations are required for imports or exports to or from Northern Ireland. So as I say, they're complicated, they require specialist knowledge, specialist software linked to the HMRC, and it's important to get them right to avoid overpaying and delays. Your local Chamber of Commerce can help. Chamber Customs is their customs advisory, training and brokerage service. Chamber, Google Chamber Customs, and they'll provide help and they'll train your staff and make customs declarations for you. But capacity is limited to ensure guaranteed delivery, so do contact them now. But There is a customs grant scheme. There is a pot of money which closes next June for customs brokers, freight forwarders, and traders who do their own declarations. You can apply £12,000 per person for a new member of staff recruited or a redeployed member of staff, and £3,000 towards the actual recruitment costs. And there is a grant for IT as well. First come, first served, and even for getting up to speed and training, you don't have to be doing the customs declarations yourself. You can apply. So strongly recommend going on that website. So we come on to services. And shrouded by uncertainty, it has to be said, the World Trade Organization identifies 4 modes by which services can be traded across the borders. Mode 1, Mode 2, 3, and 4. Mode 1 is a cross-border supply. For example, an architect in Manchester working on a project in Berlin, or a UK customer using a call center in France. And what this table shows is possible changes that might happen. This is all shrouded by uncertainty, and what you might need to do. So mode 2, for example, with a Spanish nurse training in the UK, there may be travel restrictions, the regulations relating to domestic recognition of overseas degrees and training needs to be clarified. So it may well be that there might be some restriction on the recognition of qualifications. Commercial presence, an Italian bank opening branches in the UK, well, there might be different licenses, and we'll see what happens with a trade deal to see about foreign direct investment in the UK and vice versa. So a lot of conjecture around that. It's important to identify what consumption you are having or what service you are giving, and then we'll look for the clarification as and when a deal eventuates. This slide now looks at the free trade agreement between the EU and Japan. That's the FTA heading. So again, this is gives an indication of what we might expect if an agreement is reached. As you see, single market is all green, there's free movement, but where we go red, we have significant constraints, and where we go amber, there are some notable constraints. It's clear that British services exporters are not going to have the same access to the EU as they do currently. So a bit of crystal ball gazing, we'll see what happens, but certainly if we do end up with well-paid jobs moving out of the UK, it's going to have a huge knock-on effect. So I'll hand over now to Garant, our VAT director, to talk through some important VAT implications. Garant, are you there?
I am indeed. Thank you, Paul. I hope everybody can hear me. So if we just do a quick run through some of the headlines in terms of VAT. So the headline, I guess, the UK becomes a third country for the purposes of the EU. As Paul has said, we've already officially left the EU. We're in the waiting room at the minute. That means that a whole host of VAT rules currently impacting us as a member of the EU change, and some of the things that UK businesses can currently do in the UK, or the way those transactions are reported, changes. So we'll look at some of those in a bit more detail. So the first change is that all the B2B sales of goods from the UK will become exports. Now that probably doesn't mean they're going to be subject to UK VAT, but it does mean, as Paul's already talked about, that there will be a lot more paperwork to report. The reporting by the customers in Europe will be different, and there will be a difference in the way these things are managed and controlled. The flip side, goods coming into the UK will be imports. So UK import VAT is going to be payable for the first time in 20 odd years. The good news is the UK government announced some time ago that they will bring back a very odd scheme called postponed accounting. So instead of paying VAT at the point of imports, which is what happens at the moment, for goods coming in from, let's say, outside the EU, so America or Japan or whatever, it will be done under a system very similar to the one that currently takes place for goods coming into the UK from the EU. You're going to see basically self-accounting. That's actually really positive news for those people that currently import things from outside the EU, because all of a sudden they are not going to have to pay VAT as the goods arrive. So there's a plus for them. But again, it means more reporting and different reporting. Foreign registration. So those UK businesses who, for one reason or another, have currently got registrations overseas in other EU member states. The fact that we will become a third country probably changes, in many cases, the rules as to how those registrations will operate. It may also create a need for people who have not had to register in the past to have to register somewhere in the EU. And one of the things that we've already seen is we're now seeing the majority of none of the 27 saying that UK companies will need to appoint a formal fiscal representation in their representative, I beg your pardon, in their country if they want to be registered or need to be registered, or indeed if they need to import goods. Can we have the next slide, Kirsten? Excellent. So, if we look at imports, as we said, we've got goods coming into the UK and goods going out of the UK into the EU. Local VAT will be due when it arrives in the country. Again, some local deferral rules, so you may not have to pay it as it arrives, but in the 27, you don't have the sort of postponed accounting that we're being introduced in the UK. So you are going to see a cash flow cost of VAT having to be paid as and when the goods arrive in the 27, and that VAT then being recovered either by the customer or an intermediary or whatever. And as I said, we're going to need a lot of UK companies who need registrations will need fiscal representation. Now, a fiscal representative in the VAT world is a very formal appointment. It brings with it some risks, and it's not, generally speaking, a thing that can be sorted out overnight. So if you do need fiscal representation, you need to make sure that you find somebody who's prepared to do that. If we're then looking at B2C exports, which obviously have become an increasing part of the picture in recent years, particularly for those people who trade on platforms like Amazon and eBay, we will see the end of distance selling registrations for UK companies. So they will need to look at alternative arrangements with registering somewhere else in the 27, looking at creating new reporting requirements to account for the VAT on those B2C exports, or looking at setting up structures whereby it's basically the customer that accounts for the VAT, which will perhaps come as quite a surprise to many customers who are not expecting to pay, let's say, German import VAT when their item arrives that they've ordered from an Amazon supplier in the UK. So those types of traders will need to think carefully about their structures. If we just move on, Kirsten. I think whilst there are lots of issues around regulatory and other matters, staff, etc., as Paul has intimated from a VAT perspective, the impact basically on business-to-business services is probably going to be very limited. I don't think there's any great desire either at the UK level or the EU level to impose additional VAT on cross-border services. The likelihood is that the reverse charge procedures that are currently in place that deal with most B2B services will remain largely unchanged. But people need to bear in mind those things which are not covered by the reverse charge. And I think the one that probably causes the most issue is land-related services, particularly things like event admissions, where the liability to VAT rests by relation to where the event takes place, not where the supplier or the customers are based, and crystallises the need for UK event organisers to be registered overseas. B2C services is frankly a bit of a mess, and assume unless we get some sort of very special rules, perhaps in some sort of free trade agreement, we are going to see some big changes there, especially for electronically supplied services. Those UK businesses currently using the mini one-stop shop or MOS to account for VAT on electronically supplied services will need to move to the equivalent non-union system, which is the system currently in place for suppliers from outside the EU, which is essentially the same kind of system, but what it will mean is you're now going to have to register under that non-union system in one of the remaining 27 countries of the EU to account for your EU sales. I'll now go back to Paul to talk about GDPR.
Thank you, Garant. VAT, a huge area which we will be covering in greater detail at a future webinar in itself. So GDPR contracts generally, in terms of mentioned about Incoterms being needed to be in place, and the clarification as to how to resolve any disputes within the contracts. So far as GDPR itself is concerned, we hope that there will be a deal, and because that will avoid the issues around personal data transfer between the EU 27 and the UK. GDPR itself is unaffected because both the EU 27 and the UK abide by the GDPR regulation. But certainly watch this space on what we can do with data that comes out of EU 27. It may well be that we have to introduce some new contractual clauses in any agreements. The latest information, go to the Information Commissioner's website for further details. It may well be that, worst case scenario, you may need to have a representative within the EU 27 to take responsibility for data transfer. If you've got a .eu website, you should have already had an email from the EU warning you that unless you are a EU citizen or have a presence within the EU 27, then those websites, web domains will be terminated. There is a further warning letter coming out on the 21st of December. They're very precise on their dates. But .eu domains disappearing. Okay. Travel in a post-Brexit world, well, fairly straightforward. You must have more than 6 months on your passport, and obviously ensure you have the right travel insurance. Driving documents, remember the GB stickers, travelling across on a ferry, those will all be needed. International driving permit and insurance, as I say. The EU ID cards will no longer be valid as travel documents from October 2021. So if you've got members of staff that have an EU ID card and you require them to travel back to the EU 27, they would need to get passports rather than just the EU ID cards. And the upcoming is a travel authorization system visa waiver, rather like the US has. More paperwork, more cost further down the track. Have you confirmed with your data roaming position with your mobile phone operator? That's probably important as well. And if you've got any pets, that's going to be even more of a headache for you, shipping your pet over to Europe. So some action points as we wind up. We've covered all the points, I think, but there's certainly some actions, I'm sure, for you to look at. If I was going to pick out any one in particular, I would be looking at clarifying who's going to be the importer of record if you're pushing goods across borders, and knowing what tariffs you're likely to be in for, assuming it is no deal. Next slide, thanks, Kirsten. So trademarks we haven't touched on, that again is a subject all on its own. Broadly, no trademark owner is going to lose any rights that they held before Brexit, though in some situations there might be additional steps needed to keep those rights in place. EU trademark registrations will automatically be cloned onto the UK register. But again, look into that in more detail. We've talked about cash flow. Mark may well have a comment to make in the panel session on cross-border cash payments, which are tax-free at the moment, but may not be post 31st December between various entities. And Geraint touched on VAT deferment, postponed VAT, and setting up an account for that. Next slide. So the British Chamber of Commerce have a very, very helpful dashboard. The link is there, and it covers all the areas covered by Brexit, and it sort of offers a traffic light system as to where we are with all the questions broadly that are asked by businesses, not specific to a particular business, but it covers people, funding, tax, regulation, digital trade and borders. And there are still, out of the 35 questions, 19 where gaps are still there and information is still weighted, and 7 where we've got wholly inadequate information on which to plan. So that's the state of play with 77 days to go. And finally, at Moore Kingston Smith, we've developed a BX360, which is a series of exploratory questions relating to your Brexit risks and opportunities, covering all the key areas, and we'd be very happy to discuss that with you as to how that can be of great benefit to you and your Brexit planning. It's not too late, but it's still very much to the fore. I hope that's been useful. A quick whiz through. Sorry for the technical hitches, but we got through it. I'll hand back to Mandy, who's going to run the panel.
Lovely, Paul. Thank you very much indeed. Can everybody hear me? A little thumbs up from a panel member if you can. Brilliant, thank you. Thank you very much. We've had a load of questions in advance, and we've got quite a few in the Q&A as well, and some that Richard has been diligently answering away during the course of Paul's presentation. Multitasking par excellence. Just to reiterate again that we will be circulating a recording of the webinar, copies of the slides, and some frequently asked questions after the webinar. We've got a lot of detailed questions, and this area is possible to get into infinite detail. So I'm going to ask the panelists to cover at a fairly high level because we haven't got time to dive into some of the infinite detail. But can I suggest that if you want to ask more, you get in touch directly with your normal Moore Kingston Smith contact, or indeed any one of us on the panel, and we can point you in the right direction to have a subsequent conversation. A lot of the questions that came up in advance related to how services get dealt with, and much of that I think Geraint covered in his part of the presentation. But we've had quite a lot of questions specifically on selling services in the cloud and selling software and things like data. So as we had quite a few questions on that, Geraint, can I just ask you to say a few words around that to kick us off, please?
Yeah, I think certainly if you're looking at B2B transactions, the likelihood of there being any significant changes to the current VAT treatment is pretty small. As I said in the panel, as I said in the discussion, I don't think either the UK or the EU has any urge to tax B2B cross-border transactions by and large in any way that's different from the way they do it at the minute. Where the differences will come for these types of transactions, I think, will be B2C transactions. So if you are selling, for example, computer software to a private individual, then you will have to look at registrations in the EU under the non-union MOS scheme and account for VAT that way, which is different to the way you operate at the minute.
Okay, lovely. Thank you very much. We've also had another couple of questions around how it would work if we've got a UK holding company with a EU subsidiary in Ireland or even on mainland Europe, and what would be the pros and cons and how would that work? And I'd like to put that one to Mark, please.
Thank you, Mandy. Can you hear me okay?
Yeah.
Yeah, so that sort of situation is not uncommon at all, and a lot of companies, certainly that are based in the UK, that we predominantly advise are in the process of setting up entities in the EU where they don't have them already. For a lot of valued commercial reasons, a lot of businesses in regulated sectors may not be able to transact with EU customers unless they have a presence in the EU, and therefore they need a company or a branch over there. Equally, some customers in the EU, for very specific reasons, will often not be prepared to deal with another business that is not based in the EU. So it's definitely an issue, and there are tax issues that come with that. So I primarily focus on corporation tax, on corporate taxes. And the classic example is you've got a business perhaps at the moment that currently deals with EU customers, but needs to set up a subsidiary in an EU country going forward to facilitate that same business transaction. You're going to be paying corporation tax or the equivalent, local equivalent thereof, in the EU. And that's going to be likely to be the case even if you don't make an accounting profit in the EU in any particular jurisdiction. There are going to be rules, local rules, that essentially say if you've got an entity here or a trading presence, we are going to impute some sort of taxable profit on you if you don't do it yourself. In the flow through for a branch, that's probably not a massive problem, assuming the rate of corporation tax paid in the branch in the local jurisdiction in the EU is the same or less as it is in the UK. Now, that's going to be an issue because our rate of corporation tax is 19%. If you've got a branch in France, the rate of tax there is nearly double that. So you're not going to be getting relief for all of that French tax, and therefore your tax bill on your profits has gone up. Equally, if you are receiving dividends from subsidiaries that you perhaps currently have or will need to set up based in the EU, at the moment they are free from withholding taxes because of the European directives that apply there. They won't be going forward. They'll be subject to withholding tax potentially on the basis of the tax treaties that exist between the separate countries within the EU and the United Kingdom. For example, Germany levies a 5% withholding tax on dividends coming to the UK. That's gotten rid of by the current directive, but it won't be going forward. So when you couple that with the fact that dividends aren't taxable when they're received by UK companies, you've got a 5% cost on that dividend repatriation. So if you're setting up in the EU as a result, or you have operations in the EU, you're going to need to consider not just tax, not just VAT, customs duties, but also sort of structural repatriation of funds, funding, and just general tax on trading. Sorry, a long answer to a short question.
Well, I did say it's a deeply complicated area. Thank you very much, Mark. The next question is on people, and so it's coming your way, Richard. Here's the heads up. We've talked a little bit about what needs to happen to EU nationals living in the UK and UK nationals in the EU, but there have been quite a few questions around how it's going to work if you deal with contractors through an agency, so agency workers.
Yeah, slightly different that. It will fall under a different set of rules. So it falls outside of an employment relationship and into more of a corporate relationship. So the corporate rules would apply. And the employment rules won't, I guess, is the answer to that. But again, we'll just have to wait and see what is going to happen.
Okay, but presumably if you're currently supplying UK residents to an EU country, you might end up having to offer the local job to EU nationals before UK nationals? You might. So as in with the UK, if we're looking for people, if we're looking at the rest of the world, essentially at the moment we have to advertise the job for 3 months, and before we can even offer it to somebody who doesn't fall out inside the EU at the moment. So yeah, it could be extended to EU as well. Yeah. Okay. Thank you. I've got a couple of specific questions I'm going to dive into. We've got one. We're a marketing communications agency that helps brands roll out marketing campaigns internationally and provide translation services. We work with a lot of third-party freelancers based all over the world that complete the work. Will they invoice us with VAT going forward? Garant, that one is winging to you.
Probably not.
Okay, because?
They should, apart from perhaps one or two countries with a VAT system somewhat different to the EU's, like Australia, I think, and possibly Brazil. Most of that would be subject to the reverse charge in the UK, and certainly as regards European-based translators or copyright.
Okay, brilliant, thank you. Another specific, this is an employment question. We've got 2 employees in Southern Ireland being paid on from our UK payroll. Will the payroll process need to change as a result of the changes?
Potentially, yeah. So this is such a massive topic, this now. So the fact is that, you know, really we can have people working anywhere in Europe, can't we? And we could keep them on a UK payroll. That might be okay per se. I think there's going to be huge tax implications going forward. You as an organisation could be potentially having some tax implications. Do you need to set up an entity over there in Southern Ireland? Yeah, it's going to get really, really complex. And global mobility, this is going to be huge post the end of December. And what's relatively straightforward now inside the EU, it could get very, very complex going forward. And I know this week I don't know if anyone picked it up, but this week in the FT, one of the major banks, one of the major Swiss banks that's operating from London, has allowed all their senior execs to work from wherever they want to in their holiday home all over the world, and now they're looking at a massive tax bill, and they've told them all to come back. So I expect this topic to get more and more complex as we move closer and closer to the dates.
Yeah, absolutely. I don't know, Paul, if this is a question we know the answer to, but there's one here. Are there any plans to remove the FSCS £85,000 bank balance protection for non-UK banks post-Brexit?
I haven't seen anything about that. They're probably concentrating on wider issues at the moment. We'll have to see what comes out from the negotiations. Whether they'll go into that, I don't know, but I haven't seen anything yet.
Okay, thank you. I thought maybe not. There's a supplementary question, Geraint, on your answer on B2B services. You say that B2B won't be impacted, but if selling DDP, you still have to pay VAT and duty. So you have duty as extra cost and VAT unless you register for VAT and claim it. Or am I missing something?
Well, you wouldn't pay duty on supplies of services.
No. Okay.
So I don't fully understand. I mean, there is going to be an increased cost in terms of, for the first time in a very long time, goods moving both ways across the UK-EU border will be subject to duty either in the UK or the EU, or potentially both.
Yeah. Okay. Right. So just going back to one of the questions that was submitted in advance. Apologies, I've put it down in the wrong place.
Can I just pick up on something that Paul said earlier about having it in your contract? So the Paul's absolutely right that you should have right to work in your contract of employment, and but just please do bear in mind that even if people don't have the right to work in the UK and they're here, they're still protected by the employment tribunal services. So don't go around firing everyone at will, because even though they don't have the right to work here, they can still take you, unbelievably, they can still take you to an employment tribunal for unfair dismissal. So you do need to make sure that you're following due process in those situations.
Okay.
Which sounds bananas, but that is the way it works.
Thank you, Richard. We've got a couple of questions saying what's going to happen to TOMS, the Tour Operators Margin Scheme, after the 31st. Geraint?
That comes back to my point. We become a third country. The Tour Operators Margin Scheme is an EU piece of legislation. It therefore ceases to have direct effect in the UK. At this point in time, HMRC have simply said that they intend to keep, quote, an equivalent arrangement for UK tour operators. Some UK tour operators may also need to register in the EU and account for VAT under TOMS in one or more member states. That's where we are at the minute.
Okay. Listen, thank you very much indeed. We've reached 11 o'clock. There are more questions than I could cram in by running on for 5 minutes, that we haven't answered. So we will follow up with some frequently asked questions that kind of cover these things at a broad level. It will, I'm afraid, be impossible to dive into the detail on every single one, but please, as I say, do reach out to your Moore Kingston Smith contact if you would like to have a more detailed discussion. We will send round a recording of the webinar. We will send round a copy of the slides, and looking at some of the later questions, we will also send around details of forthcoming webinars looking at some of these areas in a great deal more detail, because it's evident that A, there's a great deal of interest in it, and B, there's a lot of stuff to get through. So thank you very much indeed for joining us today. Thank you very much indeed to our panelists for your insight and information, and look forward to seeing everybody at the next Brexit webinars and the next MKS General webinars. Thank you very much.